The Civil Procedure Code provides for the jurisdiction of various courts and also states that courts should not take cognizance of subject matters for which it's either expressly or impliedly barred by the civil procedure codes. Now, the issue that arises is that a lack of jurisdiction in a court cannot be cured by the consent of the parties. Therefore, it is important and imperative that you approach the right court. The jurisdiction of the courts are dependent on three factors: the pecuniary jurisdiction, the territorial jurisdiction, and the subject matter. The pecuniary jurisdiction deals with the amount of claim involved, which allows you to choose the right forum for having the jurisdiction over the disputed claim. The second is the territorial jurisdiction that ensures the convenience of the parties, a speedy trial, and an effective trial to ensure that the court having the jurisdiction over the subject matter, the defendants, and the suit property within the territorial jurisdiction to effectively pass orders. And the third is the subject matter of the dispute. For example, there are certain specified subjects. For example, a dispute under an electricity act goes to a special tribunal where it is the state commission, from where it goes to the appellate tribunal for electricity, and then to the Supreme Court. Similarly, for the telecom matters, the dispute first goes to the TDSAT, which is the Telecom Disputes and Appellate Tribunal, from where it goes to the Supreme Court. So, all these factors are taken into consideration at the time of determining the jurisdiction of the courts. Please also note that the onus of proving the jurisdiction of a court is on the person or the party which is filing the suit.